or their management.
Good morning and welcome to Law Talk with Ethel Mitchell. Now for today's show. Here's attorney Ethel Mitchell.
Law Talk with Ethel Mitchell is sponsored by Equity Resource, a development, construction, and investment firm that is transforming properties throughout the Washington, D.C. metropolitan area. Our mission is to develop properties at a high level of value, a low risk of investment, while providing impeccable service to our customers. When you're ready to sell, renovate, or invest in a property, choose Equity Resource. Call us today at 202-621-6632 or visit our website, equityresource.net.
Welcome back. I'm your host, attorney Ethel Mitchell. Welcome to all who are listening live on WOL station 1450 AM, throughout the world on WOLDCnews.com, and on LawTalkWithEthelMitchell.com. This program is also brought to you by my law office, Wills and Trust, LLC, where I prepare wills, trust, power of attorneys, advance medical directives, and other documents. So if you or someone you know needs a will, a trust, or assistance administering an estate, call me at 202-772-1988. That's 202-772-1988. This is also a live call-in show, so please call us at 1-800-450-7876, 1-800-450-7876. My radio engineer, Darrell Farley, is here to receive your call. And my executive producer, Stacy Royster, is also here with me this morning.
Good morning.
Good morning. You hear me say every week that law is powerful. It can help you or it can hurt you. It impacts everything you do. What you don't know can hurt you, but what you do know can really empower you. It helps you to get your affairs in order. All kinds of affairs. It helps you with your day-to-day life. People have been calling me about a lot of things I don't do, so it's kind of, I try and refer them to lawyers who can help you. But there are lawyers in contract situations, in employment situations, in all kinds of situations that law has an impact, and it's very important for you to use our services and to learn and to make use of what the law allows you to do. But remember, what you hear on this program is for information purposes only. No attorney-client relationship is established by anything said on this program. Each person's circumstances are different, and you really must seek individual counsel for your individual situation. The programs are archived at LawTalkWithEthelMitchell.com, so if you missed a program or you just want to hear it again, go to LawTalkWithEthelMitchell.com, and the programs are posted there. The audio is there. Today we're going to continue to talk about wills, trust, but today I think I'm going to concentrate on probate. What in the world is probate? It's a situation that a lot of people hear about. A lot of people find themselves involved in it. During the break, Stacy was saying that at one point, she knew a lot of people whose family homes were in probate.
Yes.
I mean,
I didn't understand it.
Yeah.
I'm thinking this was their mom's home or their parents or their grandparents.
Mm-hmm.
They've died, and you hear around the neighborhood or what have you. What's going on with so-and-so's house? Oh, it's in probate.
It's in probate.
And that's something I didn't even understand.
Right.
How do people get there, and then how do you get out?
Okay, that's a good question. A lot of times people ask how you get out of it. Anyway, probate is a court procedure where when someone dies and they have property, the courts, even now they call it unsupervised, but in a way it is supervised still. Under the auspices of the court, you are able to transfer property from a deceased person into living persons. Okay? In general, that's sort of a broad definition of it, because the probate division of the court is a section that's what they do. Sometimes it's called Register of Wills. Sometimes it's called Orphans Court. It has a different name. Sometimes it's a part of the clerk of the court. But it is a process that begins with the filing of a petition that petition requires, in general, throughout almost any state or any place that you're doing it at, you need to have the death certificate of the person who died.
Mm-hmm.
You need to know their address and where they, and also the place of their death, and of course when they died. You need to know who their next of kin were, whether it is a spouse, if they had children. Maybe they didn't have a spouse, but they had children. You need their names, their addresses, and you need to be able to know what their relationships are. Some people don't have any children. Then you want to look for the parents and the brothers and sisters. Again, for each of those persons, you need their names and their addresses. You need to report to the court what property it was that they died owning.
And who is this doing this reporting?
The person who files the paper to the court is called a petitioner.
Mm-hmm.
The law gives different people the right to file this petition.
Mm-hmm.
If the person had a will, the person in their will would say, this is my personal representative, and that authorizes that person to file the petition.
Okay.
If the person did not have a will, the law of intestacy governs, and that's a law that every state has, and it says when a person dies without a will, this is who inherits their property and in what proportions. And it doesn't matter what that person said to you verbally over the years. It doesn't matter what their intentions were. The law of intestacy will govern if you've not put it into an enforceable will. Okay? So when there is no will, the law also has certain preferences that says who has, first right to file the petition. So if it is a person who's married, their spouse has first right. It doesn't have to be the only person, but first right.
Mm-hmm.
A creditor can file a petition. So if somebody died and they owed money to somebody, the creditor can come in and file the petition. It's not common, but it is doable.
And
Okay.
can multiple people file a petition because they don't know someone else's
and that's
petition
where
in
the
court?
first fight often happens.
Okay.
The first fight often happens when you don't have a will and you haven't appointed anybody. Then let's say you have no spouse, but you have a bunch of children,
Mm-hmm.
and the children don't get along.
Mm.
And so now the children are fighting over who should be the personal representative, because that person is going to be in charge of the property. And if there's no will, again, each child has an equal right to be the personal representative and to be the petitioner. In some instances, you have dueling petitions, and the court has to decide. Often when the court sees that, however, the court will appoint a lawyer who is not a member of the family, because it appears when you're fighting like that you can't get along. And so the court will appoint somebody else who is going to charge you extra money, to take over the property. So that's just the beginning of the process. That's the beginning of the process. Now, let me step back a little bit and explain that there's some kind of property that has to be probated, and there's some properties that are not probated. Mm-hmm. So there's what we call probatable property, and there's non-probatable property. The kind of property that does not have to go through probate is property that by its title transfers at death, and that's payable on death beneficiaries. So, for example, if you have a bank account, you have a savings account, checking account, if you have a brokerage account, and you say, when I die, this is who I want to get this, and you say it on a form, all banks have payable on death beneficiaries, please make sure it's on their form and it does not name a child, okay, a minor. It's not wise at all, because then nobody can get to it. The court's still going to get to it. But anyway, you can do payable on death beneficiaries on your bank account. You, of course, everybody's familiar with it on life insurance policies.
Mm-hmm.
Those assets pass without going through probate.
Because you've already designated.
You have designated it in a legally enforceable way, and so they bypass probate. That's called a non-probatable asset. Okay? So please call in, by the way, 1-800-450-7876, 1-800-450-7876. This is information that a lot of people don't understand, but they need to know. Non-probatable property could also be a house with a deed that has either transfer on death provision, like D.C. and Virginia created transfer on death deeds. And so I'm encouraging everybody, even if I did your will for you, years back, a lot of times, sometimes, there wasn't that law at the time that made it, doable in a wise way. You can always put somebody's name on your deed, but we've talked over the years about why you don't want to do that sometimes for tax reasons as well as liability reasons. But now you can do a deed that says only when I die does this person get this house, and so there's no interest that they have while you're alive, and that means that their creditors can't get to the house. Now, once you're dead, then hey, it's theirs.
Just a quick, point of clarification. What if your house is not paid for?
Doesn't matter.
Upon death, and you say, I want so-and-so to get my house upon my death. What happens?
They get the house, but they got to pay for it.
And if they can't,
then they better sell it because the mortgage company is going to get their money, okay? The mortgage company is going to get paid, okay? So yes, and that's something people don't think about. Mm-hmm. When you want people to have your house, you need to make sure that at least they need to know how they're going to pay for it.
Someone who has the ability to not only pay for the remaining mortgage, but if the house is paid for, also the taxes.
Oh, yeah. Taxes, insurance, keep it up. Now, one of the things that you can do with a trust is if you have a trust and that trust has money in it, you can provide that the trustee, using the trust money, will pay for the expenses of the house.
Right. Okay.
Okay, that's doable. All right. You can even provide, if you do a life estate, we've talked about that, where you say, I'm going to let my brother or my sister live in the house for their life, and then when they die, it goes to so-and-so. And I'd like to put, if I do that, then I like to say, but they have to pay for the expenses of the house. Mm-hmm. Sometimes they cannot afford to. If you have someone who's ill, or mentally unstable or something, then you have to make other arrangements, okay, which you can do. But you have to put that in writing so it's enforceable. But let's go back to the probate. Once once you identify what property the person has, and that property would be bank accounts that have no beneficiary designations on it, bank accounts that are not owned with somebody else, okay? Because remember, if you own a bank account with somebody else, if your statement says Stacy or Ethel, then when I die, Stacy now owns all of it. Okay, so that's not a probatable asset. But if it's just Ethel, then I die, it's got to go through probate. You've got to go through probate, okay? So your petition for probate starts by identifying the decedent, their death certificate, identifying their next of kin. If there is a will, you submit the will also. A lot of people think if you have a will, you don't have to go through probate, and that's not true. Depends on the assets. Wills are very helpful when you do have to go through probate. In D.C., you can say in your will not only who's to be personal representative, but you can also say it's to be unsupervised, which makes it much easier, much faster. You don't have to report as much. You still have to use the proper proceedings and so forth, but it certainly helps with the management of it, not having to do reports and not having to get permission all the time, okay? So you start there. That's how you start. You identify what property the deceased person has. In some states, they ask for what debts they had as well. So if they had a mortgage, you would say. If they owed hospital bills or whatever, you would say those things. Whatever. A lot of times when you start the probate, though, you don't know that. That doesn't mean that you can't do it. You go on and start it. You file the petition, and you, with the death certificate, you give the court the information about who the next of kin are and their addresses. Each court is a little bit different, but once that's done, there is a publication that's done. There's a lot of paperwork goes into this, okay? But there's a publication of a notice that says so-and-so has been named as personal representative. If you are a creditor, you have 6 months to file your claim or you will be forever barred, okay? And if you are an heir and you have not been named, you need to file your claim as an heir. That's basically what those notices are. Is it a requirement to
publish in like 3 local papers or something?
It depends. In Maryland, it's one paper. In D.C., it's 2 papers. You know, it really does depend. And in some courts in Maryland, they send out the publication. In D.C., they send out the publication. The newspaper then sends the lawyer, if the lawyer is doing it, the bill. And you have to prove to the court that you've done that publication. And you don't get that proof of publication until you pay that bill.
Interesting.
Okay? You also, again, now we start to, you know, states are different, but you have to send a notice to everybody who is an heir. Even if you have a will that does not name all those heirs, you have to send, or somebody has to send a notice. In some states, like in Maryland, they send the notice. It's called a list of interested persons. And those are people who would have inherited from the person.
It could be a pop-up heir, huh?
Oh, yeah. Oh, yeah. Or it could be a creditor. You know, they are entitled to get notice that the estate has been opened and given a chance to file their claim. Okay? If somebody dies, maybe they were in hospice or they were in a nursing home, and there's an unpaid bill there, that's where hospice or nursing homes would come in and file their claims. Okay?
So how do companies such as a hospital or nursing home or hospice become aware, you know, if you don't happen to read that particular paper in that given week?
You can,
it's, you know,
each we call them jurisdictions, but each area has certain newspapers that they publish these notices in. And, for example, like Discover Card, they have a whole company that I think watches all this stuff. They watch and they see when it comes up, and then they file their claim. Okay? Medicaid is now filing claims in D.C., for example, that a lot of people have received Medicaid, you know, during the latter part of their lives, and Medicaid in D.C. is filing claims now, too. So these are all debts, doctor bills, and hospitals, and ambulances, and so forth like that. They file their claims. And so if there is any money in the estate or assets in the estates, those claims are reviewed by the personal representative. If you agree with them, then at the end of the period, of the publication period, when you have collected all the assets, before you distribute to the heirs, you pay the claim. If you dispute the claim, then you file a notice of disallowance of the claim. And then the creditor has to come in and prove
that you in fact
owed the money. Okay, and sometimes that happens.
Records just get crossed over.
They get crossed over, or what I ran into situations where a lot of these credit card companies also have people buying insurance that they call what is it called? It's something like, well, older people think that they're buying insurance to pay off their credit card, you know, if they die owing money. And a lot of credit card companies do have that insurance, okay? Even if you don't buy it, they've got it. So they're going to pay it off, okay? But one company in particular had an older gentleman. He was 89 or something like that when he died. And he was getting billed every month from 2 different insurance companies. And then the credit card company said, no, that wasn't for that. That was if he lost his job. Oh. I was furious. I was like, no, we're not going to go there, you know.
Wow.
So we disallowed the claim, and we had to fight about it, you know. But you want to be careful when you have credit card claims and so on like that. If you're paying for insurance and you think it's going to pay off your credit card bill, make sure, really and truly, get it in writing. Or, because there's a lot of these companies that will charge you money. Then there's insurance policies for if you die in an accident.
Right.
Okay, if you don't die in an accident, you don't get nothing.
Death by suicide, it cancels out.
It cancels out the insurance. That's right. That's right. So back to probate. Those are all the kinds of, if you owe somebody money, they have a right to come in and claim. They have to prove it. They have to establish, that you agreed to it. Another part that a lot of people, I encourage them to file claims. A lot of times when the probate is opened, nobody is paying the bills of the home. The person has died. Sometimes there's somebody living in it. Sometimes there isn't. But the electricity still has to stay on. The water needs to stay on so the pipes don't freeze.
And who has to pay for this?
Well, has to is, I don't like to use that term.
Should be.
Well, number one, the heirs and the personal representative should be. In some instances, they do not. And sometimes either an heir or somebody else who knew the family will make those payments, and those payments will add up over the time, because sometimes it takes a long time for the process to go through. And I've had people who were not heirs of that direct estate pay up to $19,000 in expenses to keep the house in good shape, so that the estate could then sell the house. In that instance, I then filed a claim for that person against that estate. So I tell people, it's okay, keep your receipts, use checks when you pay bills and so on, and then we'll file a claim against the estate so that you can get your money back. You see, so that as long as it's a legitimate expense of the estate, and the estate has money to pay you, okay?
There's some estates that have $0.
Don't have money,
right?
Or if you've got a house and you don't want to sell it for whatever reason, and there's just not any money there, then you got another problem on your hands. But by and large, with or without a will, the process of beginning the probate is what I just described. You do the petition. Sometimes there are other documents that you have to file. You always have to have the death certificate, and you need to have the names of the heirs. In some states, when you don't know everybody, because some families are huge,
just don't know.
You can file an affidavit of your attempts to try and locate everybody. But that's the process. That's how it started. The person, whoever is appointed by the court, then has the responsibility of managing, keeping the property insured and in good order. That's part of the responsibility. They marshal all the assets. So they go to the bank where the bank account is. They open an estate account, an estate bank account. I will get an EIN number, an employer identification number, for the estate.
That's smart.
Because you don't want the personal representative's Social Security number being used, because it's not their money. You see what I mean? No, absolutely, you don't commingle. You do not commingle at all. But that's how the estate account opens. I understand we have a call. Daryl, hello, good morning.
Good morning. Yes, I wanted to say up front that your program is so needed, and I do enjoy listening to it, and I do
thank
take
you.
notes.
Thank you.
I'm in the notes, and I'm interested in trust and also in the probate that you're speaking about today. And maybe another day you can really go into who would be a trust that you would put in your money into their name and that kind of thing. Why would you choose that person?
Okay, that's a good program. That's a good program. I'll do a program on that soon.
Appreciate it.
Okay,
Thank you.
Sure. You're quite welcome. Thank you. Please feel free to call in, 1-800-450-7876, 1-800-450-7876. We're talking about probate today. So I was trying to describe the process of the probate. The whoever is appointed as personal representative, their responsibility is to get all the assets of the deceased person together. You open an account in the name of the estate with the personal representative signing. And then you go to any bank where the deceased person had money. You bring your letters of administration, which are documents that are sealed, that are signed by the judge, but also sealed. They have the seal of the court on them. You bring your letter of administration, which is your proof that you are the personal representative of this person's estate, and you bring the document from the IRS with the EIN number, and sometimes the banks want to see the death certificate as well. But you go to the bank and you ask them to issue a check to the estate of the deceased person. Okay? So you can either get a cashier's check, or if you've already opened the account, they can wire the money into the estate. If you are selling the house of the person, you go to the closing. The title company, the settlement company, will have already asked to see the documents of your proof that you are the personal representative, you have the authority to sell the property. If there is a mortgage on the property, a lot of heirs think they have to pay off the mortgage. No, at the settlement, the mortgage is paid off. Okay? So the settlement company will get directly from the mortgage company the payoff figure, it's called. The mortgage company will let them know how much money has of the purchase price in order to pay off the mortgage. And so when you go to settlement with a good idea. A lot of real estate people will tell you don't need a lawyer, because they just want to get past it. They want to get done. They want to get their whatever. But lawyers are very useful because, number one, we can look at the HUD-1, it's called. That's a settlement document where every dime is listed. And most people don't know how to read those statements. And a lot of times there are questionable expenses on those statements that you need to have explained. And sometimes they're right and sometimes they're not.
You need an expert.
You really do. And I'd like to talk to the settlement company and make sure I get the HUD-1 a day or so ahead of time so I can look at it. I don't want to just sit there and go through it, line by line and ask questions right at the table. Everybody want their money, So before we even walk into the settlement table, I like to have already gone over and approved the statement, even if they don't have every dime on it. Sometimes there's still some things outstanding. You may not know how much the water bill is, or you may not know this or that, but you know how much the taxes are that have to be paid. You know how much the payoff figure is. So anyway, long story short, once you're appointed as personal representative, if you choose to sell the property, it is always easier to sell the property while it is in probate than to go through probate, put 10,000 people's name on the deed, and then try to sell the property. Okay? That is so hard to do because you have to get everybody to sign the deed and to be in approval of the deed. So when I come back, we're going to continue talking about probate. Okay? Stay tuned.
Best in soul food, it's Levi's Barbecue, featuring their lunch specials Monday through Saturday from 11 a.m. to 4 p.m. Salisbury steak, liver and onions, meatloaf, chicken, and filet of fish. And you can choose any lunch special you like. Generous portions to satisfy the heartiest appetite. When you think of soul food, think Levi's Barbecue. Located at 6201 Livingston Road in Oxon Hill. For more information, call 301-567-0050. Or log on to levisbbq.com. Are you looking for a red-hot DJ that plays all of your favorite dance tunes? Well, look no further than Mr. High's Oldies and Classic R&B, where it's all about you. Professional services for birthday celebrations, anniversaries, family reunions, private parties, wedding receptions. Over 40,000 songs are available. Mr. High's Oldies and Classic R&B. Call 301-520-8223 or send him an email at mrhigh222@aol.com.
News Talk 1450 WOL-AM, where information is power.
Welcome back. You're listening to Law Talk with Ethel Mitchell. I'm your host, Attorney Ethel Mitchell. And today we're talking about probate. What is it? How does it work? What needs to be done? What are the steps? And why does it take so long? You know, because it does. It does. And one of the reasons that a lot of people choose to do a trust is because they want to avoid the length of time of probate and all the technicalities that go with it. But let's continue with probate. So, I was explaining that when you are the personal representative, you have to marshal all the assets of the estate. You go to the banks, you get the money out of the bank account directly into the estate account. I tell people, make a copy of all checks that you receive. Keep your deposit slips. Make sure that you label where the deposit comes from. Do not use online statements solely. You really do need to have paper statements for this, even if you don't get checks like you used to get. But, you need the statements to prove what you've done, because you have to establish, if somebody raises a question, you are what we call a fiduciary. And that means that you have to show what you did. A beneficiary has a right, an heir has a right to see what you did. And so you apply for any kind of refunds that might be. Maybe there's a car that needs to be sold. You have access, you have title to that car now. You are able to sell that car and sign the papers. Again, I tell people, go down to DMV or MVA to sign the title over and make sure that that title gets out of the name of the decedent and into the person who paid for it. Because again, I've known people who quote unquote sold the car and then find out a couple of years later the person never changed the title. There's a car accident and the car is still in the name of the deceased person, and so you can become responsible. So you want to collect all of the assets. We talked about the house. If you plan on selling the house, you can sell the house at that point. It is so much easier, if the intention is to sell the house, to do it while it's in the estate, because the personal representative is usually, certainly if you have a will, and in most courts, even without a will, they are authorized to sell the property. Now, if you're an heir and you don't want the house sold, or you think it's not being sold properly or whatever, you have the right to come in and object. But 90% of the time, 99% of the time, it's an amicable situation, and you are trying to liquidate or transfer everything into money, because money's just easier to distribute. If there are refunds, insurance refunds, it can be all kinds of refunds. All that money goes into the estate account. You do an inventory at the beginning that says, this is what we know about is in the account. Okay, we know that the person owned this house, they had these bank accounts, they had this personal property. Personal tangible property includes cars, furniture, clothing, jewelry, things like that. In Maryland and in D.C., there's an appraiser that will come out and appraise the car, the boat. I've had estates that had boats in them. You appraise a boat, appraise the jewelry, the clothing, and so forth, and they do a written appraisal. And so all of that becomes part of the probate process.
And Ethel, if you have appraisals already for jewelry or furs or other items, are those valid in these circumstances, or does an appraiser still
They can be if they're
thing?
fairly recent, because the appraisal for all of these things are to be done as of when the person died. You see, so you could have gotten appraisal 10 years ago. Well, that would not be valid. Okay. Everything starts from the date of death of the person.
Okay.
With houses, you don't have to go out and buy an appraisal usually. Most courts will accept the assessed value the assessment for tax purposes. You know, when you get your tax bill, you can bring that in, and most courts will accept that as the value of the home. Okay. Then you let's say you decide to sell the property, and you go to closing. The money, any debts on the house, line of equity, equity line of credit rather, mortgages, anything like liens, all those things are paid off, and the estate receives the balance of the money.
Okay.
Okay, so it's just like any other situation. There's a balance of the money. Several years ago, when things were underwater, we had to get permission for short sales. And in one situation, it took us a long time, but we were able to finally, get it was a condo sold on a short sale because the estate had no more money, and the heirs didn't have the money. And so, we finally explained, look, either you take this or we're going to walk away from it because there's nothing to do. You know what I mean? So, but that's the process. Okay. After all the 6-month period is up, all the assets are collected. If there are any claims, they have been resolved one way or the other. You prepare what's called a final account. And if it's an unsupervised estate, you submit copies of this account to all the heirs, that say, this is what we received. This is how much we got for the sale of the house. This is what came from SunTrust Bank, from this, from that, all the various places. If you received interest, you report that interest and so forth. If you sold a car or whatever, you report all of that, and then you recite all the bills. In most cases, even if somebody else paid the funeral bill, that's actually a bill of the estate. Okay, if you have a will, the will often say, if it's done by a lawyer, it will say you authorize the payment of your funeral expenses in spite of whatever the law restricts it to, because the law says you could only pay so much for a funeral. So if you don't have a will, then that money can only be paid from the estate up to that level. If you have that in your will, then whoever paid for the funeral can get their money back.
Get reimbursed.
Okay. The expenses of administration, their court fees, their publication fees, their lawyer fees. There might be appraisal fees. There might be, if it's a home, it has to be taken care of. There may be yard fees, whatever. In the market today, we don't normally recommend that people spend much money fixing up a house, because people who are buying them are often investors who,
and they'll expect
they're going to tear the house up and fix it all the way they want it anyway. Okay, but you do want to keep it in good working order. You want the water to run, the electricity to be on, and all like that. So you account for everything. That's why it's called an accounting. You account for everything. And then at the end, you say, this is what's left. If there is a will, you then say, we propose to distribute pursuant to the will. And you recite to the sections of the will. And if the will says, 100% to my daughter, Stacy Royster, then you propose to distribute what's left that way. If it says in shares, then you do it the way it says. If it says give $10,000 to different gifts, to my church, to my godchild, to my school, whatever the will says, you distribute, or you, in your accounting, you say, this is how I propose to distribute. Okay? If there is no will, then you recite to the law of intestacy, which says this is how it is to be distributed if there is no will. So if you had a spouse and children, you go to the law of D.C. or Maryland, wherever. The law that governs is the law of the domicile, that's called of the deceased. Of the deceased. And that is their primary place of residence. Some people have more than one residence, and that's different. You could live in D.C. and have a home in North Carolina, for example. Then we look at where do you spend most of your time? Where do you vote at? Where, where are your more significant places of contact?
Okay.
And, for the deceased. And you look at that law, and it says how it's to be distributed. Usually it's in percentages, like the husband gets half, or the spouse gets half, and the children get half, or whatever it is. And that's how you distribute. You use the law to make the distribution. You give the heirs a right to look at this. In other words, you send it to them. If it's a supervised administration, you file it in the court. And there's a notice that goes out that says, here is
everyone.
All of them, and it says, this is what we propose to do. You have, in some instances, 30 days, in some instances, 60 days to file any objections, okay? So if you have any objections, you can come in and say, I don't like this, I don't like that, it ought to be this way, or whatever it happens to be. In many instances, there are only a few heirs. And if so, the lawyer sends out the report, the final account, with a consent form. And usually you've talked about this stuff. I mean, it's been going on a year or so now. And so you've been talking to the heirs or the lawyers for the heirs and, what's happening and so forth like that. And so you kind of know where people stand. And you send out a consent form. And if the person is in agreement with what you propose to do, they sign the consent. And when you get all of the consents back in, then you can make the distributions.
But if there's one person out of the 5 who disagrees,
then you got to go to court. You got to try to either negotiate an agreement, or the judge has to get involved and make a decision. And that takes time. It just takes a lot of time.
So some or most of this could be avoided, or all, if you had a will.
Well,
in most cases.
No, the will, again, if you have a will but you have assets that have to be probated, you still have to go through the process. But because the will says what you want to happen, it says who's in charge and what you want to have happen, then that's what's going to be followed.
Okay.
Okay? So even though it may take time, it doesn't take as much time as when there is no will, there's no direction, there's nobody, has more control than others, and who the heirs are and everybody else is kind of up for grabs. So you really want to have a will, even if you don't want to trust, and even if you do have to go through probate. Having the will short circuits a lot of stuff.
Okay.
It really does. It really makes it work.
I mean, after hearing you explain all that you have today, I understand why the difference.
There's a big difference, and that's why a trust can be very, very helpful, because with the trust you don't go through all of that. With the trust you don't go through all of that. The trust allows you have to not only have the trust, though, you have to, what we do call funding the trust. And that means that you put your assets in the name of yourself as trustee, or in the name of the trust some kind of way. And so you don't have to go through probate to get it into the trust. But when I come back, I'll try and finish the program talking about probate, and then we have a few good news sections that I want to share with everybody as well. Listen up and stay tuned. Thank you.
News Talk 1450 WOLAM, where information is power.
Those of us who were around in the 50s and 60s struggling, many of us have gotten tired, and we let the enemy have his way. Well, I did my best, they'll say, and you all take it now. I'm just going to sit down and relax or retire. I have never seen a lion retire from being a lion. I may not bite as hard as I used to, but I can still bite.
Don't miss the Farrakhan Speaks broadcast this and every Sunday at 8 a.m. until 9 a.m. right here on WOL 1450 AM, where information is power. That's the Honorable Minister Louis Farrakhan on the air this Sunday at 8 a.m. If you missed last Sunday's
DMV, like we always do with this time.
Ready for the best circus ever? Get ready for the Universal Circus! For the young at heart and for the people that
I thought it was real good. Everybody was great.
So you say you saw it last year or you've seen it before?
It's definitely different.
It's something new every year. Don't miss out. Going on right now through July 19th at the National Harbor. Visit UniversalCircus.com for tickets and details. Sponsored by McDonald's. Deeply rooted in the community.
News Talk 1450 WOLAM, where information is power.
Welcome back. You're listening to Law Talk with Ethel Mitchell. I'm your host, Attorney Ethel Mitchell, and I've been explaining the process of probate. Our call-in line is 1-800-450-7876, 1-800-450-7876. If you need me to work on something for you, whether it's administration of an estate or preparing wills, trust, or estate planning documents, you can call me at 202-772-1988. That's 202-772-1988. For the past hour, I've been explaining probate, how it works, how you get property from a deceased person to persons who are alive. And that's effective for property that has to be probated. There are non-probatable assets, I explained, like payable on death beneficiaries, transfer on death deeds, life estate deeds. There are other ways of transferring property, but the primary way in which you can get property when those things are not in place, even when you have a will, is through the process of probate. And as I explained, you start with the petition of probate, you have the death certificate, the will, and the names and addresses of all the heirs. You submit to the court what property you know about the person had during their lifetime that needs to be probated. You submit any bills that you might know about that the person had. And you go through the process of distributing the estate. I understand there's a caller, Daryl. Hello? May I help you? Hello? Yes, good. Now I can hear you. Yes. How can I help you?
Yeah, okay. I have a sister, and she's 82 years old, and she has a touch of dementia. And when it comes to legal documents, I mean, she has given me power of attorney. So by her having dementia, how does that interfere with things?
Well, hopefully you have what's called a durable power of attorney, which allows you to continue to operate even if she does have dementia. Okay, and it may be that we can look at what assets she has and figure out a way to properly transfer those assets so as to avoid probate. We may or may not be able to. If she's not able to sign a will at this point, and that's a whole nother show about the capacity that's needed. She could have dementia but still be competent, but that's another show. I don't have time to go through that at this point. But if, let's assume she does not, it may be too late to get a will done. Okay? And at that point, we would have to sit down together and see what needs to be done. Whatever you do with your power of attorney, please remember it has to be for her benefit. Whatever you do has to be for the benefit of the principal. So you don't use a power of attorney to benefit yourself. That's the main thing that you have to be careful about. But short of that, depending on what kind of property she owns, we would have to sit together and figure out what needs to be done and what can be done at this point.
Okay, when I try to take care of certain business for her, especially some insurance company, and I send them a copy of the power of attorney, they will not accept that. I don't know, like they got some special form or something that they want.
Yeah.
So if I get the durable power of attorney, would that solve the problem there?
It may. It's wise to get somebody like myself to do the power of attorney for you, simply because each state has their own form, and so you want to make sure that you have something that is usable in that particular state. And what I'm concerned about is she competent to sign it at this point? I don't know.
Yeah, she's competent enough to sign, and
okay.
That's why she made me power of attorney. But I was just certain things I was trying to take care of, and the insurance company in particular, they just will not accept it, even though I sent them a copy of the power of attorney.
Yeah, not all power of attorneys are created equal, shall we say? But seriously, there's some language that needs to be in certain power of attorneys to be able to do certain things.
Okay, all right. Thank you very much.
Okay, you're quite welcome. Daryl, is there another call? Okay, may I help you?
Is that me?
Yes, ma'am. Can I help you?
Yes.
This is Attorney Mitchell. Yes, ma'am.
I have a question.
Yes, ma'am.
My question is about Social Security.
Uh-huh.
I am a senior citizen. I used to get, SSI and the SSD.
Uh-huh.
And the next year, maybe a couple of years ago, they denied me SSI because they told me I have over $2,000 from the bank.
Mm-hmm. They'll do that.
That is true. So now, they told me also to pay back, because 1 year I used to get, SSI.
Oh.
Yeah.
Okay.
And I have a problem, when I talk to Social Security people, what you have to do is if you have over $2,000, you have to take out and do something. They just give me some hint.
Yes.
They did not tell me everything. They try to help me.
I tell you what I would want you to do, because although I know some about it, this is not my area of expertise. But if you call me at the office, I can give you the name and number of lawyers that I know that do know Social Security very well. And they know how to work with them and work with this situation, okay? So if you call me at 202...
I have some people, I'm just asking you, but I have another lawyer also too.
Oh, okay. Yeah. Well, right, good. You're quite welcome. Bye. Have a good day. Goodbye. Yes, ma'am. Goodbye. So what I'm going to do, because we're, oh my goodness, about to run out of time. So I want to, we had some good news stuff. If you have any questions about probate or if I can help you, give me a call at 202-772-1988. 202-772-1988. I had several things I wanted to share with you in the good news section that I try to do, don't always make it, but try to do each week. One is a wonderful play that I went to that I want to share. It's at the Anacostia Playhouse. It's called Occupied Territories. It's the story of a Vietnam vet. It's really set in what they call theater in the round. So you have the daughter who was born while the man was in Vietnam and has had difficulty because he suffered from what we would now call post-traumatic syndrome. So she was always distant from him, and she didn't understand why. You see her in the round, but then you see what happened to him in Vietnam. And it's so well done. It is so well done. I would encourage you to check out the Anacostia Playhouse. It's at 2020 Shannon Place Southeast. Unfortunately, today and tomorrow are the last days that they have the performance, but it is just excellent. It's called Occupied Territories, and what was unusual about it was they allowed, after the program, the audience sits in a circle around the stage, and afterwards the cast came out and sat in chairs, and we could talk about it. So that was very unusual. I thought that was excellent. Beginning in, I think it's July 17th, they have another play coming up called American Moor, and it's the story of a African American man who is an actor, and he's going to talk about race and theater. So that looks like it's going to be another good one. I found them under Theater Alliance, theateralliance.com. but I would encourage you to check it out, the Anacostia Playhouse at 2020 Shannon Place Southeast in Washington, D.C. The next thing I wanted to share with you is this wonderful book. I was a history major, and I still love reading history. Truth is, to me, more interesting than fiction usually. And there's a great book. I'm going to try and get the author on. But, as we celebrate, America's birthday and all like that, there's a book called The Half Has Never Been Told, and it's Slavery and the Making of American Capitalism. It's by Edward Baptist, who is a professor at Cornell University, and it's just an excellent book. I'm trying to plow through it, but it's fascinating to read about what the United States really was like in 1776 and 1780. He has so many different facets and facts that, for example, Abraham Lincoln's grandfather was called Abraham Lincoln. That was his name. And he was on the frontier in his yard, and a Native American killed him with a shotgun. And then his nephew or somebody like that, I don't know if it was Abraham Lincoln's son, killed the Native American with a shotgun and thing. But there are all these different interactions among the North and the South and slavery and why the different compromises were made and the political compromise that allowed the South to be so powerful in our country and really resulted in slavery continuing for so long. That is I think it's something that we need to know. And it's called The Half That's Never Been Told. Lastly, I want you to enjoy the rest of the week and check out Dustin Brown, who beat Rafael Nadal in Wimbledon. He knocked him out of Wimbledon. Young black guy from Germany and Jamaica. Quite a story there as well. And check out his story, because he really pursued his dream in ways that were just I was surprised when I read the story. So check that out. Google him, Dustin Brown at Wimbledon. There's a great interview of him on ESPN that's online. Enjoy the rest of the week. Enjoy the holiday, and I will be back next week.
1450 WOL, where information is power.